Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in our country over the past week or so. And as is the norm, tonight we have a packed agenda for discussions. I want to welcome our viewers who are joining us on television from region number 5, West Coast Berbice. Welcome to another program of Issues in the News. To our viewers again on television who are joining us from Region 6, East Bank of the Berbice River, New Amsterdam, Kanji, and all the way along the Quarantine Coast. Welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live right across the length and breadth of Guyana, the Caribbean, North America, Europe, and even as far as Asia and New Zealand. Welcome to another program of Issues in the News. Please share the live, press that share button on your phone so that you and your friends and followers can join us in tonight's discussion. Also, please use that comment section that is scrolling in front of you so that you can share your views, you can partake in the discussion, you can raise issues for me to address, or you can pose questions for me to answer. Please share the live again. I appeal to you. Press that share button on your computer, on your phone, on your iPad, or whatever device you may be using to view the program. Thank you and welcome once again. I want to begin by speaking about an outreach program that the Legal Affairs Ministry did in conjunction with the Deeds and Commercial Registry Authority in Region Number 1 at the Mabaruma Regional Compound. That is the compound of the Regional Administration Office. This outreach was an initiative of His Excellency President Dr. Mohammed Irfan Ali, and it came out of an outreach that the President did recently in Region 1, and he made a promise and a commitment that we will hold this outreach and that we will establish a permanent office of the Deeds and Commercial Registry Authority in the locality of Mabaruma. Pursuant to that promise, yesterday I led the delegation from the Attorney General Chambers, the Public Trustee Office, as well as the Deeds and Commercial Registry Authority. The outreach was a spectacular success. We conducted in excess of 100 transactions, all of which were completed. We completed far over 100 transactions. We met with over 100 persons. I was able to sort out dozens of land issues. Mabaruma is a place riddled with land issues because most of the land there are state lands and persons are occupying based upon leases. And there are a large bundle of legal issues relating to land occupation. I was able to call the head of Lands and Surveys, Mr. Moniz, and also work along with the staff of the Lands and Surveys Commission who is at Mabaruma, and I was able to give legal advice that ought to guide the Lands and Surveys Commission in resolving hundreds of land disputes, because the problems are, while they are manifold, the issues have great similarities and commonalities. So once you give advice on a particular issue, once that advice is followed, then it would impact positively on the resolution of hundreds of these legal disputes that are facing residents of those communities. We also registered, rather the Deeds and Commercial Registry Authority registered 77 new businesses and issued the certificate of registration immediately. We notarized dozens of documents. You know, simple services like notarial services are not available. So persons would have had documents that require notarization for years and have been unable to have those documents notarized. So we had a notary public present as part of the delegation, and that person was able to notarize dozens of documents. We did also dozens of transactions involving affidavits of identity, deed polls, and addressed many issues affecting persons, the misspelling of names and clerical errors on persons' birth certificates, marriage certificates, and in some cases even on their ID cards. So we had the help of GCOM, we had the help of the GRO, the General Registrar's Office representative at Mabaruma. They were all part of the outreach, and they obviously offered their assistance in helping us to resolve all these issues. Of course, the office will now be opened. An office of the Deeds and Commercial Registry will be opened at Mabaruma in the Regional Administration Compound, and will be staffed by the Deeds and Commercial Registry Authority, and that office will be there permanently. Importantly, we are executing another outreach program of a similar nature at Port Kaituma next week. So next week, Monday, we will be at Port Kaituma with a similar team of persons, and we will conduct a similar outreach, offering the variety of services that we have offered at Mabaruma. Even most importantly, a decision has been made to conduct this initiative in all our hinterland regions, in the tongues of these regions. So we will do one in Region 7, we will do one in Region 8, we will do one at Region 9, and we will do one in Region 10. And it is our hope and expectation to establish a permanent office of the Deeds and Commercial Registry Authority in all these regions. You would recall APNU AFC government, as they usually do, they embark upon a lot of ceremonies. So they establish these townships, but never even attempted to install in these townships the requisite services that a township would require. It's not that we were opposed to the establishment of these townships, but we had made the criticism at the time that establishing a township is simply not declaring the place a town, which is the requirement by law, and establishing a town council. It's much wider and much more embracing than that. It is putting a constellation of services in that locality that would qualify the place to be a township. And that they never did in all their 5 years in government. So they may very well be critical of what we are doing now. But the truth of the matter is, they never did it. So, Mabaruma doesn't have a bank, but it's a town. It never had a commercial and deeds registry office, but it's a town. Madhya doesn't have a bank, but it's a town. It lacks many of the facilities that townships would have and are required to have. It's the intent of our government to put those services there, but it will take time. We will do the same thing at Lethem, at Bartika, and of course we are going to do it in Linden in terms of establishing offices of the Deeds and Commercial Registry. And this helps people. First of all, it makes doing business easier. So persons do not have to expend large sums of money to travel to Georgetown to conduct these businesses or to access these services. But more importantly, it encourages regularity. It encourages people to formalize and legalize their businesses. So as I said, yesterday alone, we registered 77 new businesses in Mabaruma. We may surpass that number when we go to Port Kaituma. These were 77 persons who were conducting their businesses but not being registered to do so. Now there is regularity and compliance with the law, and there is now a formal business community that can be established. And look how many persons needed the type of services which we were able to offer yesterday. And we plan to do these types of outreaches all year round. I will concede that we should have done this earlier, but it's better late than never. So I wanted to report on that. I am told, I have the statistics here, the Deeds and Commercial Registry Authority generated $389,500 yesterday alone in fees that they collected for the services rendered. So while it will have a cost, these are also revenue generated activities. The sole purpose is not really to collect revenue, but to offer the services. But like everything else, there is a cost attached, and there is a cost recovery mechanism. We plan to build buildings in the future so that the Deeds and Registry Authority can have its own accommodations in these several regions that I have mentioned. That's the grand plan, but everything takes time, but we are getting there. We are getting there, and that is what modernizing the country is about. When we speak about modernizing the country, it's not lip service, and it's not only talk. We are following it up with concrete actions for the benefit of all of our people, wherever they are located. And another important dimension that I must mention is that when these offices are established in these localities, they provide employment as well to the persons who are qualified to work in these offices in the very locality in which they are located. We are not going to hire persons from Georgetown to work in these offices. The persons right in those areas will be the persons who will be employed. Right now, I am told that there is an advertisement out inviting applications from suitably qualified persons to fill the posts that will be created when the office begins to function. So that is also a work in progress. So I anxiously am looking at your views. Haro Shivratan, Hari Sankar, Joycelyn Bishop Hussein, Zina Durga, good evening to all of you. And I see someone here making a reference to Nigel Hughes. I will deal with Nigel Hughes in due course. We are not going out there for photo opportunities and making self-serving appearances. We are actually delivering services to the people of Guyana when we go out on these outreaches. They are not Kodak moments. They are not photography sessions and video opportunities for persons to propagandize themselves on Facebook and other social platforms. We are actually delivering services. And don't tell me that we are in government and it is our duty to do so, because that is true. But there was another government just 3.5 years ago, and they did not do this. In fact, the people complained bitterly that Basil Williams led some type of initiative in Mabaruma, collected the people's money for registering their businesses, but never delivered the certificate of registration. They took the people's money, the people had their receipts, and never delivered what they took the monies for. You know what we did? We walked with the computer, we walked with the printers, and as the people paid for the services and they filled out the requisite applications for application forms, we delivered the documents right there. We generated the documents at the spot at the same time. That is efficiency. That is forward thinking. And we did not stop until we addressed the concerns of every single person who turned up at that outreach. So not a single person turned up at that outreach and their issues were not addressed. Maybe we didn't solve all the problems, but everyone who came had an opportunity to speak with us, and we got an opportunity to address them, their concerns, or offer the relevant advice to them, as the case may be. And before I close off on this matter, I must thank the hard-working staff of the Ministry of Legal Affairs and the Attorney General Chambers, the Office of the Public Trustee, and the hard-working staff of the Deeds and Commercial Registry Authority. They did a remarkable, they did a remarkable job in addressing the concerns that were raised and efficiently dealing with the transactions that the persons came there to conduct. So next week, importantly, we will be at Port Kaituma, where a similar initiative will be undertaken. So the folks at Port Kaituma and surrounding areas, if you are listening to me, please spread the word that our team will be at Port Kaituma and we will be offering these services. And to all the persons in Region 1, you will now have a permanent office of the Deeds and Commercial Registry Authority located in the regional administration compound of Mabaruma, which is the capital of the region. Last week, Guyana, through the agency of the Attorney General Chambers and Ministry of Legal Affairs, in collaboration with the Caribbean Court of Justice Academy for Law, hosted a very important law conference at the Georgetown Marriott. And I am pleased to say that it was a resounding success. We had nearly 300 persons participating, including some very high-profile participants. Those include the Secretary General of the Commonwealth, Miss Patricia, oh Lord, I can't remember. Patricia, I'm so sorry, the name slips me. So Baroness Patricia Scotland, yes, Baroness Patricia Scotland, my mind is somewhere else. And her delegation, we had several judges from the Caribbean Court of Justice. We had several heads of judiciary, including across the region, several heads of judiciaries across the region, including our own Chancellor of the Judiciary here in Guyana, Chief Justice Louis Blenman of Belize, and the former Chief Justice of the OECS Court. Her name is slipping me. And also several judges from across the region and a number of directors of public prosecutions, including, of course, our own. We had law professors, we had many lawyers from across the region. It was a packed program, very intellectually exhilarating, very intellectually stimulating, and we discussed for 2 days a number of key and critical issues regarding the criminal justice system of Guyana, and of course, the entire Caribbean. Because the problems that we are facing in Guyana are not unique. Many of those problems are being faced by the legal systems of the rest of the Caribbean. And we had many, many papers presented, many lectures delivered, and we are in the process of collating all that information. And then, of course, we will make it public and we will distribute it to all who participated. Also, the Department of Public Information, DPI, is working on a comprehensive package of video interviews and other materials that they would have accumulated at the conference, and they are packaging it to broadcast to members of the public. So, and of course, I have received glowing letters and emails of congratulations and expression of gratitude for a very successful conference. And also we were complimented for our hospitality and the excellent logistics and other arrangements which were put in place for all our participants, but more particularly from those who traveled from out of the country. I want to take this opportunity to thank all the persons, and there are so many of them that I can't begin to name them, who worked tirelessly and worked dedicatedly to make the conference the success that it was. I did the least. The staff of the Attorney General Chambers, there was a planning committee that had persons from across the region, the legal profession of Guyana, the judiciary, staff of Foreign Affairs Ministry, the Guyana Police Force for the security and other support services that they offered, His Excellency the President for hosting the cocktail and for attending and also delivering to declare the conference open. So thank you. Yes, last week, Friday, I read for the first time a very important bill, the Matrimonial Causes Amendment Bill of 2024. This bill does two major things to our matrimonial law. First of all, our Matrimonial Causes Act, which is the principal act, is over 100 years old, so it definitely needed updating. And this bill updates it. Although it deals with two fundamental issues, we use the opportunity to update the Matrimonial Causes Act, because there were many things in there that were really overtaken by time and by developments in the law. So, for example, in that act, and it is still the law, so I have to speak in present tense, in our Matrimonial Causes Act, there is something called restoration of conjugal rights. What that means is if there is a break in conjugal rights or a breakdown in conjugal rights, meaning living parties living together, and they have a dispute and they become estranged, one of those parties could have approached the court and get a court order directing a restoration of those relations. It didn't matter that the two persons can't live together anymore, that the marriage has broken down irretrievably, that there is great fracture in the relationship and there are irreconcilable differences. One party could have gone to the court, in particular the husband, and get an order to make the wife come back in the matrimonial home. Now, that perhaps was what was legally and socially accepted 100 years ago. But now we have reached a position in society where the law itself permits a husband to be charged for raping his wife. Let me repeat that. Currently, a husband can be charged for raping his wife. That didn't exist 100 years ago. So, essentially, when you are directing, when a court is directing the restoration of conjugal rights, the court is also authorizing that man to have sexual relationship with that woman, even though the woman may not be consenting. Today, that is rape, but that's still in our law. So that will be removed once this bill is passed. Secondly, there were many rights which women did not have 100 years ago that women have now. And as a result, there were certain facilities that men could not enjoy, that would be considered offensive now, where you have equality of gender and the right to equal treatment irrespective of gender, race, religion, class, stature, etc. So in an environment where equal treatment is now a guaranteed fundamental right, you cannot have unequal treatment. And throughout this legislation, women were treated differently from men and men treated differently from women. And throughout the Act, we have now changed that wherever we found this inequality of gender, and we have now changed the language to ensure that there is gender equality and equal treatment to both the husband and the wife. So that's another important aspect of these amendments. And we have a ruling from our Chief Justice, the Honorable Roxanne George, which was handed down a few months ago, which I agree with. There is a provision, one of the unequal provision in our current law is the right of a wife to seek and obtain maintenance from a husband, but no right conferred upon that husband to be able to seek maintenance and upkeep from the wife. In short, only a wife under our law can apply for maintenance from the husband. A husband has no right to apply for maintenance from his wife. And the Chief Justice rightfully struck that provision down as being contrary to and inconsistent with the provisions of our Constitution, which guarantee equal treatment and freedom from discrimination irrespective of gender, race, religion, etc. Because that provision discriminated against men, and it created an unequal treatment between men and women on the basis of their gender. That has now been removed, and now the provisions are gender neutral. So a husband can claim maintenance from his wife, and a wife can claim maintenance from her husband. Another significant addition that we have made to the Act is that we are making to the Act is we are listing a number of factors that a court must take into account when determining whether to grant maintenance and the quantum of that maintenance. And it applies, as I said, to both a husband and a wife. So the bill lists those factors, a number of them. And I am hoping that the journalists who are looking at the program will get a copy of the bill and read it. And let me apologize, not journalists. All of you must read these bills. Read the law. You are expected to know your rights. How can you be able to protect your rights unless you know them? And that is why I have instructed that a Facebook page of my ministry, Attorney General, be created, and that has been done. And all these bills are uploaded there. But more importantly, in government, we have put the official gazette online, and all these bills are gazetted. They are published in the official gazette. And you know why? So that you can read it. So you don't have to go to any printry or the office of the president or the parliament or the attorney general chambers to get access to these bills. You can read them on your phone, on your computers, in the luxury and comfort of your home. And please do. I am trying as far as I can to get the drafters to write in the simplest of language so that everyone can read and understand law. Gone are the days when sentences used to be long and very circular and circuitous on legal documents. I am moving away from that. And we are now drafting in plain English so that every one of you can pick it up and read it for yourself. The other most important amendment that this bill puts forward is something that we have been trying to do for a very long time, and we were unable to accomplish the task. Under our law, we don't have what is called no-fault divorce. We have fault-based divorces. That's the current law. What that means is that when you file your petition for divorce, you have to find a ground and establish to the satisfaction of the court that ground before you can get a divorce. The grounds are, in Guyana, malicious desertion, adultery, cruelty, or a person or one of the parties, well, not one of the parties, the husband has been guilty of rape, sodomy, or bestiality. Rape, sodomy, or bestiality, the husband had to be guilty of, and that had to be established to the satisfaction of a judge. Or you have to establish adultery, or you have to establish cruelty, or you have to establish that the parties, one party maliciously deserted the other. Unless you can prove those things, you can't get a divorce. And this has led to innumerable problems in our society. Persons are forced to live separate and apart. Well, first of all, you have one set of situation where the persons got to live together because they can't get a divorce. Then you have another set of situation where the parties have severed all relations, but they can't get a divorce because you have to prove one of these things. And that it's not easy to prove, especially when one side is contesting. A judge now has to hear evidence. And what is worse is that the most nasty set of details can come out in divorce petitions and in evidence in a court, and is publicly done. Damaging the relationship between the parties forever and permanently. And the people, the persons who suffer the most while this matrimonial war goes on are the children of the marriage. Are the children of the marriage. People have divorce petitions pending in the system for years because they have to go through the long ordeal of a trial, and they live separated apart. And you have maintenance relationship going on, you got custody fight going on. The rest of the world has moved away from this position. The rest of the world has moved away. And they have put a provision in the law that allows the parties to divorce each other if there is a irretrievable breakdown of the marriage, or if there are irreconcilable differences. And that is the position to which we are moving in this amendment. There is one caveat. provided that the husband and wife have been separated and have since lived separate and apart for a continuous period of 6 months immediately prior to the divorce petition being filed. So you have to show that there has been a genuine separation for 6 months prior, before you can file a petition. So we are putting that in the law now. So now 2 parties can agree that they don't want to live together, and they simply go to court and they file their divorce. And they can even prepare the divorce petition together so that they don't put injurious things about each other. They don't wash their dirty linen, so to speak, in the public. They can agree on what facts they will put to the court and they get their divorce. But they have to establish that there's a genuine breakdown. This amendment has been in the pipeline for several years. We consulted because the religious community had felt strongly about this, and we consulted with them again, and Minister Gail Teixeira held that consultation with a large number of religious organizations and civil society organizations, and they are now on board with it. The legal profession had long wanted this, and many other segments of the society wanted this change in the law. So we are finally it will finally be changed. I don't think this bill will attract opposition from the parliamentary opposition. I believe that they are also of the view that the time for this bill has come, and perhaps has long come, and we are proceeding with it at the next sitting of the National Assembly. The other very important bill that was laid last Friday, and it was done by my sister, the Honorable Dr. Vindhya Prasad, Minister of Human Services. It is the Family Violence Bill of 2024. This bill will repeal the Domestic Violence Act, and it's a much improved version of that law. It's far more comprehensive, and it has many features and characteristics that that law did not have. Again, this is a bill that will affect the lives of tens of thousands of people. So again, I ask you to get a copy of this bill and read it. The Domestic Violence Act was passed in 1996, and after 3 decades, it needed to be overhauled. In that 3 decades, we were able to detect a number of deficiencies. We were able to identify a number of loopholes and a number of shortcomings. They have all been addressed in this new bill. This bill has both civil remedies and criminal remedies. The Domestic Violence Act only has civil remedies. So you can get charged with a criminal offense under the Act, although domestic violence itself is violence, and you should have domestic violence offenses as criminal offenses. That act does not have it. This bill will now have it. It gives magistrates wide powers to remand and to make all the civil orders that were there before with a wide range of additional orders. It extends the definition of family, so a larger category of persons can now get the protection that this family violence bill offers, far wider than was available under the domestic violence bill. It gives the police force a wide range of powers to deal with domestic violence complaints and to take immediate steps. The police do not have that power now under the Domestic Violence Act. To take immediate steps to protect the victim, to remove the victim out of the home, or to remove the offender out of the home. Significantly, the Domestic Violence Act only applies to the magistrate's court. This family violence bill applies both in the High Court and in the magistrate's court. So in the past you had the difficulty of, while you're doing the divorce cases and the custody cases for the children and the maintenance cases in the High Court, you couldn't get a domestic violence order in the High Court because the Domestic Violence Act only applies to the magistrate's court. So you had to incur additional expenses, and the lawyer had to make a separate application now in the magistrate's court to get a domestic violence protection order, for example. Now you can do all of that in the High Court without resort to the magistrate's court. These are some of the new changes that are in this bill. So again, I appeal to you to read the bill. We are quickly coming to the program time. So these are very, very crucial and dynamic, evolutionary pieces of legislation that we are promulgating in our country, all with the intention of protecting our people, all with the intention of ensuring that there is law and order in our country. Before I close, I want to recognize that today is the 16th of July, and it is the day that those of us who are concerned about democracy, we mourn the passing of the ballot box martyrs. On July the 16th, 1973, Bholanath Parmanand and Jagan Ramesar were shot on Elections Day by members of the Guyana Defense Force in their village at number 62 village on the Quarantine Coast, simply because they stood up for the right to vote and to protect their ballots. The army was sent by the PNC government to go all across the country and pick up the ballot boxes. Although the law says that that is a function of the Elections Commission, the army was sent, and the army, as you know, broke the ballot boxes, threw away the valid votes. Votes were found floating all over the rivers, and they stuffed PNC ballots in the ballot box. And that government won one of the highest majorities ever recorded in an election in this country. In 1973, the PNC did that. These two gentlemen stood up and attempted to block the army from removing the ballot boxes. David Granger was in the army at the time. He spends a lot of time defending, trying to explain that he was not around. He was very much in the leadership of the Guyana Defense Force, and they were doing this for the PNC government. Remember, he said that he was in the PNC 40 years? Well, he was in the PNC at the time. In 1973, he was there, by his own admission. These are things that we must never forget. These young men were not only shot, they were thrown at the back of a pickup truck, and they were not taken to the hospital. That pickup truck, driven by the army, went to other ballot stations, polling stations, to collect more ballot boxes, while those men were bleeding at the back. They didn't rush the men to the hospital. That's the inhuman treatment that Guyanese went through at the hands of the PNC. And those men were allowed to bleed out. They went from 62 village all the way to Crabwood Creek to collect ballot boxes, while those men were bleeding out. And then I believe they dropped them at Skeldon Hospital. After they done finish picking up the ballot boxes, by that time, the men were dead. One was 18 years old, so he would have been voting for the first time. And I believe the other one was about 26 years old. Bholanath Parmanan and Jagan Ramisar. So when we stand and we fight for democracy in this country, and we speak about democracy in this country, and we must know that people died for it, and the people who are responsible for this are still around. Hamilton Green is still around. He's an elder of the PNC. He was around when this happened. And many of them are still around. And they still want to rig elections, as we all saw 4 years ago, March the 2nd, 2020. So I will end on that high note. I thank you very much for your attention, and take care. I'll see you next Tuesday as we resume our discussions. Thank you.